Hi everyone, this is Pennsylvania attorney Evan Gutman, here to present video number 9 of my legal education series on the licensing process for attorneys, focusing on the good moral character requirement on admission, based upon my book, State Bar Admissions and the Bootlegger's Son. The full book is available on both of my websites at heavensadmissions.com and gutmanvaluations.com. Both websites also have a supplement that I wrote to the book several years later, as well as a fictional novel I wrote titled Heaven's Admissions Process, which somewhat humorously and comically compares the criteria for admission into heaven, it's fictional, with the criteria for obtaining a law license based upon the good moral character standard. So let's go here with video number 9. And what I want to talk about today is how does the state bar admissions process really work? I previously indicated in earlier videos that the goal of the state bars is to admit applicants based upon their subjective determination of their good moral character, which is not always good actually. However, I believe that the manner of assessment should be based upon objective criteria as opposed to subjective. But how do they really accomplish that? How do they accomplish giving themselves a subjective power to assess moral character? The answer is quite obviously with respect to the questions they formulate, the questions they ask, many of which in my view are unconstitutional. So the way they do this is, first of all, it needs to be recognized, as incredible as it sounds, and it does sound incredible. In order to subjectively assess an individual's moral character, the state bar admission committees actually have an incentive. They have an incentive for each applicant to file an application that is somehow false. Because if the application is totally truthful and doesn't contain information that reflects adversely upon the applicant, the state bars lack the power to deny admission. So in order to have that power to deny admission, what they kind of have an incentive to do is formulate an application that is designed to have incorrect or incomplete information submitted by each applicant, because once incorrect or incomplete information is submitted, they then gain the power to deny admission to that applicant if they want to. The corollary to that is that a fair, just, and rational application form is realistically inimical. Inimical? I-N-I-M-I-C-A-L. Basically frustrates the state bar's interest in subjectively assessing an applicant's moral character, and is therefore also frustrates the state bar's ultimate goal of accumulating power. And the accumulation of power is what the judiciary and the state bars are all about. Since the inception of Marbury versus Madison, when they grabbed the power to interpret the law, since the early 1930s, when they grabbed the licensing power with assistance of the American Bar Association and the National Conference of Bar Examiners, the judiciary and state bars' ultimate goal is to accumulate power. And a fair and just rational application form is therefore designed to frustrate such a goal. So now basically we say that they have an incentive to have an incorrect or false or incomplete application submitted by each applicant in order that they gain a subjective power to deny any applicant admission to the bar. But how do they do that with respect to the questions? Here is how they do it. First, the questions are designed to require the applicant to recall events and provide information regarding such events that are remote in time. Because the further back in a person's life they have to recall, the greater is the probability they will omit something or provide some information that is incorrect. The probability of one recollecting incorrectly increases as the period of time between recollecting the event and the event's occurrence occurred. So first, they like to ask questions requiring information that is remote in time. Provide us what happened 10 years ago. Provide us what happened 5 years ago. And they ask basically many applicants to go back and recall things that happened many years ago in their life, which is maybe a little bit easy if you're 22 years old, but if you're 55, it's real problematic if they're asking you to recall events from perhaps decades ago. That's number one. Recalling events remote in time fosters submission of an incomplete or incorrect application. Second, formulate questions that require too much detail. The more detail that is required, the higher is the probability that some detail will be omitted, whether intentionally or inadvertently. Third, formulate questions that are vague or ambiguous so that the applicant doesn't really even know what's being asked. And it's not really feasible for an applicant to call the State Bar and say, what are you asking with respect to this question? And even if they did provide an answer, they're not legally bound by a telephone answer by one individual employee or secretary. So it places the applicant in a very difficult position when the inquiry itself, the question that is asked, is too vague or ambiguous, because it leaves open the possibility that the applicant will interpret it one way, which may be a very reasonable way. And then when they're faced with a State Bar Admissions Committee, the State Bar Admissions Committee says, why didn't you tell us this? And the applicant says, I didn't know that's what you were asking. And they say, well, that is what we were asking. You didn't provide it. Therefore, you provided incorrect, false, incomplete, or misleading information. Next, number 4, formulate questions that are highly personal in nature, because any individual has an incentive themselves to not disclose potentially embarrassing information. It has always boggled my mind that State Bar Admission Committees ask questions about a person's divorce. Nobody wants to talk about their divorce. The fact that they include that on a State Bar application to receive a law license, in my view, is disgraceful. Not only unconstitutional, but morally disgraceful. But it's not limited to just divorce. Basically, as I say, they like to ask questions that are highly personal in nature. They ask things about high school suspensions. If you're 54 years old, what does it matter if you were suspended from high school for a minor incident? But they want to know. And then the 5th criteria is they like to try to have some type of catch-all question. Now, they're moving away somewhat from the catch-all questions. They're not quite as bad on the catch-all questions as they were years ago. But years ago, they literally had a question on the application, and I think some state bars still have a similar type of question. But years ago, they had a question that said, is there any other incident or occurrence in your life which is not otherwise referred to in this application, which has bearing, either directly or indirectly, upon your character and fitness for admission to the bar? Yes, when I was in 5th grade, I threw a water balloon at somebody. When I was in 6th grade, I egged someone's house. When I was 5 years old, I stole a cookie and my mother told me I was a rotten kid. How do you even possibly have a question like that? And I think some state bars do still have it, which says, is there any other incident or occurrence in your life? There's not a single person on this entire planet that could answer that question truthfully, fully, and completely. The average bar application would be at least 100,000 pages if you were to require such a question on it. So those are the main areas in how they try to achieve their goal of having each applicant submit an application that contains some type of incomplete, misleading, or incorrect information, because that gives them the power to then deny admission to anyone whose beliefs, opinions, or attitude that they do not like. Remember, the questions that they utilize to accomplish the goal are questions focusing on time, going back too far, detail, too much excessive detail, vagueness, so that you don't really even know what they're asking, and personal information, as well as, to a certain extent still, a catch-all question. The manner in which the admissions process worked is similar, not exactly, but it's similar to how the congressional committees worked in the late 1950s with respect to the McCarthy era. And it's notable that many of the bar admission cases paralleled the occurrence of the McCarthy hearings. There were the two Konigsberg cases were around the McCarthy era. The Schwari versus New Mexico Board of New Mexico case, State Bar of New Mexico case, was around that time frame in 1957. By the way, we'll be talking a little bit about Supreme Court cases in a future video, but there are a lot of key U.S. Supreme Court cases that occurred right around the McCarthy era, and they're very similar to how the McCarthy hearings function. The McCarthy hearings function basically, to summarize basically from a biography I read of Joe McCarthy, this is basically a summary of how the hearings function, which is quite similar to the state bar admissions process. Goes as follows. This is a quote. And the citation basically is in my book. Here's the quote. Have the witness in secret session get him to testify to the best of his recollection as to events from 5 to 10 years ago. Then bring him on at a public hearing. Ask him if he did not so testify at the secret session, and then give him some letter to which he has not previously been given access to, which shows that he is wrong. This then is branded as an untruth. According to Arnold, the committee long ago gave up all idea of proving such and such was a communist. Instead, they spend weeks of time in trying to catch him up in contradictions and give the impression that he is an evasive and untruthful witness. Predictably, he was then indicted for perjury. That, to a large extent, if you read the state bar admission cases and the manner in which they treat the applicants, that, in many respects, is the state bar admissions process in a nutshell. So I hope you found today informative, and we'll have the next video within the next day or two or few, whatever. And remember, love right, don't fight.